everyone. Thank you for participating in today's Time to Talk webinar, sponsored by the Young Lawyers and Diversity Conferences of the Virginia State Bar. My name is Mallory. I'll be covering a few housekeeping items before I turn it over to the moderator. Comments made during this webinar are at the sole expression of the speaker, not on behalf of the Virginia State Bar, and do not necessarily reflect the views of the organization. Finally, please check back on the Young Lawyers and Diversity Conference pages to register for the next Time to Talk Town Hall in late August, where panelists will be addressing statute removal and First Amendment rights. I'll now turn it over to today's moderator, Chidi James, to get things started. Thank you, Chidi, and panelists for being here today.
Thank you, Mallory. Thank you so much for that, for those introductory comments. Good afternoon. My name is Chidi James, and I am the immediate past chair of the Virginia State Bar Diversity Conference. As many of you know, in the wake of the killing of George Floyd at the hands of police, many in our nation and around the world took to the streets to protest and make demands for change in policing policies and accountability. It sparked a desire in many people to talk about race, or what most people call race, but what I call ethnicity, and an attempt to grapple with both covert and institutionalized discrimination. And that's what brings us here today. Immediate past chair of the Young Lawyers Conference, Farnaz Thompson, had an idea to plan a town hall discussion to discuss these issues. And actually it's going to be turned into a series of town halls. And the first one is today, and you will receive information about the next one that's coming up in August. So in this first town hall, the issues that we're going to discuss include policing and civil liability of municipalities for proven police misconduct, qualified immunity, sovereign immunity, the differences there, and governmental response to the protests and demands for change. The panelists for today are attorneys Christopher Brown, attorney Victor Glasberg, and attorney Cynthia Hudson. Each will be individually introduced and then given a question for which they will be the primary responder. If you have questions or comments, as Mallory said, don't hold them to the end, just go ahead and submit them as they occur to you. And then when we get to a point to ask questions, we'll ask the panelists. Let's see, we may not be able to get to all the questions, and you can ask them anonymously if you'd like. So let me talk about Chris Brown. Chris is the managing partner of the Brown Law Firm in Alexandria. Both Chris's father, Edwin C. Brown Jr., and his grandfather, Edwin C. Brown Sr., were Virginia lawyers who received both received their undergrad degrees from Howard University. Chris's grandfather received his license to practice law in 1941, when there were even fewer Black lawyers than there are now. He was a civil rights lawyer and filed one of the first cases on behalf of the NAACP in Virginia to require Virginia's public schools to comply with Brown versus the Board of Education. His father, after earning his law degree, was with the U.S. Attorney's Office in D.C. and was quickly promoted to try espionage cases around the country. He had a very successful private practice and was very well-respected criminal and civil attorney. He retired in 2006 and now lives in North Carolina, where his wife is now in her second term serving as mayor of Williamston, North Carolina. Chris attended attended Duke University, don't kill me, Chris, Duke University in North Carolina, where he was a running back on Duke's University football team with a full athletic scholarship. He got his law degree from Georgetown and has been practicing in Virginia for the past 23 years with a concentration on discrimination cases, including a $5.2 million verdict in the U.S. District Court in Alexandria, which was reported as the highest verdict for an individual in a discrimination case in Virginia's history. And then a month ago, he celebrated a very highly publicized successful appeal in the Fourth Circuit. And this was the case of Jones versus the City of Martinsburg Police. Now he got this verdict, he got this win on appeal, despite losing 3 times at the trial court level, where the judge dismissed the case. he had 3 appeals of the dismissals of the trial court in West Virginia, and he won each of those appeals. And that the case was recently reported, I think it was just yesterday, in the Washington Post. And his plaintiff in that case, who was killed at the hand of police, was a man who was basically stopped by the police when they encountered him walking in the street rather than in the sidewalk. He was a mentally ill man and wound up being shot by the police 22 times. So yesterday, it was announced in the Post that the case was settled after the 3rd successful appeal by Mr. Brown, and settled for the amount of $3.5 million, which is believed to be the highest settlement in an excessive force case in West Virginia history. For those familiar with damages in these types of cases, and Chris will talk about it a little bit more, a plaintiff with, like this plaintiff, had no income, no spouse, and no children. It is an incredible result, and Chris will tell us a little bit more about that. So without any further ado, I'm going to introduce Chris and say, as I've said many times before, Chris, I want to be like you when I grow up. All right. So here is the first question, which we'll give to Chris Brown. And that is, Chris, can you please tell us what obstacles you've encountered in filing civil suits against the police for civil rights violations, and how often do those cases even make it to juries?
Chidi, thank you so much. And it's a pleasure and an honor to be here with the other speakers. The challenges with these cases, they're primarily twofold. The first challenge is the doctrine of qualified immunity. It is an onerous doctrine and provides immunity to officials who do all but the most blatant and egregious acts. When you consider the costs of these cases, they require expert witnesses, and the manner in which they are defended and fought by the defendants, you have to consider whether or not it's going to be worth it. The second hurdle is how damages are calculated. And as you touched on in that very kind opening, most of the victims of police brutality and excessive force are low-income minority persons. And when you're calculating damages based on those persons' income and how to the extent their dependents relied upon them, it can become very difficult. Getting to trial can be challenging, and those challenges of which everyone's aware of can result in settlements that can be a little surprising. You know, if you Google wrongful death settlements, excessive force settlements, you'll see them ranging anywhere from $300,000, $900,000, $1.2 million, $800,000. You'll see some $2 million, and then you'll see some outliers. And that's mainly because the time and effort of expense of taking a case like this to trial, the risk of surviving on motion for summary judgment, raising qualified immunity, can result in a family expressing a desire to accept a figure that might be shocking for the loss of someone's life. In my case in particular, the one you discussed, Jones versus the estate of Martinsburg, that's in Martinsburg, West Virginia, Northern District of West Virginia. And they had a particular problem in that case. Prior counsel that handled the initial litigation before the district court failed to respond to requests for admissions timely. And those admissions were that Mr. Jones had a knife, that Mr. Jones attempted to stab an officer, that Mr. Jones refused commands to drop the knife. And as one can imagine, those admissions were problematic, resulted in the first grant of summary judgment. And it's at that point that I entered the case on that first appeal. When you have facts like that, and their admissions, and you're going up against the doctrine of qualified immunity, it can be an extremely difficult hurdle. And qualified immunity essentially protects officers if they can express any inkling that they were in fear for their own safety or the safety of others. And the fact pattern must have been, to some extent, previously reviewed by the court, because it's a notice doctrine, really, to a government actor that if you engage in this particular behavior, then you may be liable. Having a knife, attempting to stab an officer, and refusing commands to drop the knife were an easy out for the judge to grant summary judgment in the first case. The best way to approach this is try to take it out of that paradigm where the officers can so easily say they had some fear for their safety or the safety of others.
Chris, with that admission that he attempted to stab an officer, how did you win that appeal? I mean, that sounds like a slam dunk.
On its face, I think that's why they had some difficulty finding counsel. Their counsel withdrew after summary judgment was granted. But I reviewed the case, and I came up with a pretty creative approach. And as I argued to the Fourth Circuit, there is clear case law that once a subject is subdued, excessive force may not be employed. And I made the argument that there were 5 officers on top of this 50-year-old, 162-pound man who'd been tased 3 times, beaten and held in a chokehold for 17 seconds. At that point, he was subdued. He was no threat. And for the officers to back away and release him from being subdued, point their guns at him and yell at him for 6 seconds to drop the knife when he appears to be unconscious in the video, I held that we had to restart the Graham factor test. So there's a set of factors you look at to determine whether or not excessive force is reasonable. Was the victim resisting arrest? What was the nature of the crime he was suspected of having committed? What factors led to the officers being in fear for their safety? And I approached it from that angle so that I could reframe the argument and take it away from this very difficult view under qualified immunity and approach it from sort of this restarting of the clock from the point he had 5 trained officers on top of him. And, you know, if you read the oral argument transcript, the comments of Judge Gregory were fantastic. I mean, I quoted them. I quoted Judge Gregory extensively in my brief in the subsequent appeals. As we got remanded, it got dismissed again. And the reason that occurs, it may be a little confusing. How does the judge dismiss the case 3 times? Is every time we got remanded, she would say, well, I didn't reach this issue. So you have this test that occurs, and she dismisses on the first prong of the test. It gets remanded. She goes to the second prong of the test and dismisses it. And then on the second remand, she drops down to qualified immunity and says, well, I didn't reach that issue. Now I'm going to dismiss it on qualified immunity. And there was concern on our end. You know, there was a Rule 68 offer of judgment of $1 million.
Wow.
After during the second remand. And that's a close call.
Can you tell everyone what an offer of judgment is? I've had one in a case. I had to look it up to figure out what it was, but I don't spend a lot of time in federal court. So there may be people here who aren't familiar with it.
It is a powerful tool that may only be employed by defendants that allows the defendant to say, I'm going to make you this offer. It's going to be filed with the court online, public. And if you don't accept it and you get less than we've offered you, you will have to pay us our attorney's fees from this point forward that are incurred. It is a troubling tool that plaintiffs may not employ. So it was an incredibly wise strategic decision to make for them to do that. But nonetheless, we held strong and did not accept it and pushed forward.
And who was your client? I know it was his estate, but I imagine that conversation with the client might have been pretty difficult. I mean, after having the case dismissed, going up on appeal, and then coming back, and then telling a client, yes, they've offered $1 million, and don't take it. That must have been a difficult conversation.
Not as difficult as you would think. Yes, that was not it was not an unreasonable offer given the facts of this case. I'll concede that. But I'll tell you from day one, my clients had no interest to their credit in money. while you pointed out that this result, the $3.5 million settlement, is good for a plaintiff with no income and no dependents, my clients are more concerned with these officers losing their jobs, losing their pensions, being prosecuted, and they were less concerned about money. So I'll be honest, I was the one saying, this is a reasonable offer. And they were the ones saying, we are not interested, which turned out to be the right call.
Oh, that's terrific. That's terrific.
So, like I was saying, the reason I let them know that it was a reasonable offer is because, one, the admissions, which are problematic, and two, the way damages would be calculated. So there's a US Supreme Court case, very well known, widely cited, the BMW case is how it's known. And essentially, the US Supreme Court decided that punitive damages may not exceed the amount of the compensatory award, generally speaking, by more than 5 times. So if you have a plaintiff who has no income and has no dependents, and you're trying to put on evidence of compensatory damages, $200,000, $300,000, $400,000, you're going to be limited to 5 times that amount on punitives, no matter what the jury comes back and says. And the concern becomes the jury awards you $100,000 in punitive, in compensatory, not being aware of this principle, and they give you $10 million in punitives, and then there's a motion for remitter after the trial that cuts your punitives down to $500,000.
Are you permitted to tell the jury about, award us this much in compensatory? So if you were in state court, you could tell the jury what you wanted them to award for each element of damages. So in federal court, are you allowed to tell the jury, hey, we want $10 million in compensatory?
I can tell them what I want. I can't tell them, for example, like with Title VII, that there's a cap of damages of $300,000. I can't tell them that their punitives will be cut down if they exceed the compensatory by more than 5 times. So while I can say what I want, and there would be an objection if I threw a big figure out, I imagine, ultimately what the court will do will remit that verdict down to be within those guidelines.
Okay, all right, cool. Okay.
So that's the difficulty. So you have a plaintiff, generally speaking, you're going to have a minority plaintiff from a low-income community, and you're going to try and find a way to give value to that case. And I have to say, the opinion that came out from the Fourth Circuit recently, where Judge Floyd stated in the last paragraph, this has to stop, which is the reason that opinion garnered so much attention. There's no question in my mind that that contributed to the value of the case from the defendant's perspective when they reached out after the opinion came out and said, hey, let's revisit the settlement with the Fourth Circuit mediator. So I was very excited to have resolved it for the family in that manner. And there's another interesting wrinkle in that settlement, which is how I got the co-administrators, the 2 brothers of Mr. Jones, to accept it. And that is, in West Virginia, there's a very unique statute which allows a private citizen to seek a grand jury indictment. Now, the grand jury did not indict these officers after the case, after this happened, after the incident.
Okay.
But my local council filed a state court action seeking a special grand jury based on the fact that they'd been previously presented to that grand jury in a skewed manner. And that is on appeal before the West Virginia Supreme Court. That was not part of our settlement. And it was that ability for the brothers and the family to continue to pursue these officers, who all still work for the police department. One of them retired, the other 4 are still there. It was for that reason that the family was willing to accept the $3.5 million offer.
Wow, wow. And I guess they want the public to know what happened, and for there to be some punishment for the officers.
Yeah, and plaintiff's counsel needs to be aware that the Fourth Circuit joined a number of other circuits last year in an opinion which held that municipalities are not entitled to confidentiality agreements, as that is a violation of the First Amendment. And they requested confidentiality in this, and I told them, you're not going to get it. And they asked me why. I said, Fourth Circuit last year Municipalities may not request non-disparage, non-disclosure, and confidentiality agreements. And you'll note that many of these opinions, the figures are reported as to the amount of the settlement.
So another question. You had this judge who dismissed your case 3 times for different reasons. At some point, did you consider trying to get the judge to recuse herself or try to get the case away from that judge? Is that something that was a possibility or that was in your mind?
That is something that my clients would not let up on me about. I had to remind them that asking a judge to recuse him or herself requires some evidence of bias. The lawyers disagree with judges every day in every case, in every ruling that's made by the court. There is a winner and a loser. That does not mean the judge is biased. I advised them that I felt that at this time we were not going to move for recusal without evidence of some discriminatory bias on her part. Merely disagreeing with us in light of those admissions would be a difficult uphill battle to get her to agree to recuse herself. She decides that motion.
And it's probably a pretty dangerous move to make, especially if you expect to try a case with her.
And that's not the end of it. Even the settlement under West Virginia law, even if all the beneficiaries are adults, which they are, there's a sister as well as the 2 brothers, I still need court approval of the distribution. So once the order comes out remanding the case, I need to file a motion for approval of settlement and distribution, and I'm going to go before Judge Grow to have that approved.
So I've been monopolizing the questions because it's interesting and talk a lot. But do any of the other panelists have questions for Chris? Yes, Cynthia.
Chris, I just wonder, not having read the lower court opinions, on what basis did the trial court judge, lower court judge, on the 3rd remand, when she got down to the qualified immunity basis for dismissal, determine that there was anything that in this scenario that was not clearly established in law as unconstitutional, such that the officers were entitled to qualified immunity on the facts that you described?
That's a great question. I think the answer is she regurgitated her prior opinion. At that point, I have to say I was fairly confident because I saw that the way Judge Grow wrote it up was the man had a knife. He refused to drop the knife. He had stabbed an officer. The officer wasn't injured. He had a cut in his shirt. She essentially regurgitated that. She didn't really focus on the fact that they weren't on notice. She cited the Wilson case out of Maryland, Casella v. Hughes, U.S. Supreme Court, Robles versus PG County out of Maryland, all those 4th Circuit cases, and essentially said that this behavior, in light of the fact that the victim was engaged in this type of activity, holding a knife, threatening an officer, trying to stab him, refusing commands to drop the knife, that she granted them qualified immunity in an attempt to sidestep the 4th Circuit's finding on the 2nd appeal that they had violated Mr. Jones' rights. Yet she found that they were entitled to qualified immunity. And I will say at that point, I felt confident because she was not making a distinction in trying to establish that this was something they had no notice of, so they couldn't be liable for their behavior.
Because I certainly would have thought, at least on the facts that you described, and then maybe they were in dispute, the matter of the individual having already been subdued and likely unconscious, in fact, at the time of the shooting, it would appear to me that a reasonable officer would be aware that to shoot a suspect in those circumstances was clearly unconstitutional. But
I think the 4th Circuit
found a way, apparently. Okay.
I think the recent 4th Circuit opinion echoes your comments to a T. It really does.
All right, great. Any other comments, questions from anybody? All right. I'm looking up to see if there are any comments or questions from the audience. It doesn't look like I have any questions. If that is incorrect, Mallory, please let me know. All right.
Chidi, we do have one question coming to you.
Okay. And hopefully I'll be able to see where that question comes from. I don't see it at the moment. So, okay, I got the question. All right, let's see. The question is, do you think the current doctrine of qualified immunity, sorry, let me get it over here. Do you think the current doctrine of qualified immunity allows for balance? That's the first question. And if not, is there a fair way to modify qualified immunity to quell potential abuse, but still protect officers from frivolous lawsuits?
The answer to that is yes. And that is not so much, I don't have a huge objection to the language of the doctrine. I have an objection with how it's applied by the courts and expanded to protect officers from what is clearly unreasonable conduct. If the doctrine reads that any reasonable officer would know that he was violating the victim's rights, then they're not entitled to qualified immunity. The problem with that approach is the way it's applied. If you line up 10 officers and ask them, would you have known you were violating this victim's rights if you engage in this behavior? 9 of them can raise their hand and say, yes, I would. And as long as one of them does not, that officer is entitled to qualified immunity. But even beyond that, I'm critical of the US Supreme Court in Casella v. Hughes and some of the Fourth Circuit opinions, which have held that officers engaging in certain behavior, for example, in Casella v. Hughes, the officer responded to the scene of a woman acting erratically and holding a knife in her yard. He arrived at the scene with 2 other officers. They were across the fence from the woman. She was standing next to her roommate, not doing anything, making no furtive movements. And within 4 seconds, he shot her 3 times. And because he said, I was worried she was going to stab the lady next to her, the Fourth Circuit held that there was no notice because that scenario had not occurred in the past, where a potential victim was standing next to a person holding a knife. And yet on its face, it might seem so clear, you can't just open fire on people. It's Justice Sotomayor wrote a wonderful dissent saying, she's holding a kitchen knife. There's nothing illegal about that. What entitles you to shoot someone who's making no furtive movements and no gestures? And yet they found that that officer was entitled to qualified immunity. It doesn't need to be imposed that way. There should be a much more open approach to reviewing the facts to say, clearly this is something that you should not have done. It's almost as if the umbrella has been cast, the net has been cast so wide. It's troubling. It's a problem.
Thank you, Chris. Thank you. Okay. Our second panelist is Victor Glasberg. And Victor, for lack of a better term, is a legal crusader. He made a decision to focus on working for civil rights of underprivileged people and people whose rights had been violated, even before becoming a lawyer. And that was over 50 years ago when he was a Harvard University doctoral student studying history. Galvanized by the death of Martin Luther King Jr. in 1968, Victor wrote his dissertation on the people who founded the NAACP and initially led that organization. After obtaining his PhD in 1972, he went on to law school at the University of Pennsylvania and then moved to Virginia, where he practiced initially with Phil Hirschkopf. And you may know that name, very famous Virginia lawyer, who was plaintiff's counsel in the Loving v. Virginia case that struck down Virginia's law prohibiting marriage between whites and non-whites. Well, Victor has made a career out of fighting for the rights of and equal treatment of minorities and those who are disadvantaged. In his career, he's testified twice before Congress. On one occasion, he testified concerning the Civil Rights Bill of 1991, which created a damage remedy for sex discrimination in the workplace. Before that time, there was only injunctive relief. He's had numerous legal victories in his career, including a case 5 years ago in which the court declared that confining a death row inmate to a cell for 23 hours out of a day was unconstitutional. And he also, in a case just last year, he had, which struck down a state law that required people who were getting married to state their ethnicity on their marriage certificate. And that changed the law, I think, both in Virginia and in Maryland. So I could go on talking about Vic for a long time and take up the time for him to speak in the town hall, but I'm going to refrain from doing that. And without any further ado, I give you Victor Glasberg with my next question. So, Mr. Glasberg, you heard the discussion of Chris Brown's case and the obstacles that he faced. Can you tell us your view of the function of the qualified immunity doctrine and the practical consequence for our society of having strong qualified immunity laws?
Yes, thank you for that introduction, and it's an honor to be here. And let me say that it's awesome to have heard Chris, and it's lawyers like Chris and their perseverance over extraordinary odds. Three appeals is not usual. That is responsible for the successes that have been wrought in this field. So hats off to you, Chris. Qualified immunity is a disaster for civil rights plaintiffs in most areas, and for all civil rights plaintiffs dealing with police abuse. Qualified immunity is an invention of the court. It is superimposed upon 42 U.S.C. Section 1983, which says the following, and I quote, "All persons, every person who under color of any statute, ordinance, etc., subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the constitutions and laws shall be liable to the party injured." There are no immunities included in Section 1983. And perhaps Justice Gorsuch, who recently decided that Title VII includes same-sex marriage, same-sex employment protections, because that's what it says in the statute, might want to revisit the words of this statute. What the court did was superimpose upon this categorical imposition of liability for violation of rights an immunity intended to serve two principal functions, and they are articulated in the decisions. The first was to free state actors to act, because as we all know, our public servants act in our best interest, and they shouldn't be afraid to do so. And the second is to do something about frivolous lawsuits. I'll say a word about each of those two factors. With regard to the question of making people free to act without being in fear of being personally liable, Carol Schwartz, a scholar of these matters, has done an empirical study of police cases to assess what percentage of cases involve actual payments by the officers of 1 penny. I think it's less than 1%. And we know here in Virginia, most police departments and sheriff's departments receive indemnification or insurance through the Division of Risk Management. Their organization purchases effectively insurance, and anybody who does that litigation is well acquainted with DRM or the equivalent outfit that provides that insurance. I've sued many officers. I have never had one had to pay 1 penny for his defense or for damages or for settlement. So with the evolution of protections to our public servants, the rationale for permitting people to engage in their work freely without impediment or fear, really, it doesn't hold water. The second justification is to save the system from frivolous lawsuits. Here we do with qualified immunity what we do with lots of things in law. Because there are numerous problematical cases, we establish a Procrustean bed that controls all litigation. So, for example, there are lots of lawsuits filed by prisoners. Lots of them are frivolous. The response to that is not to have judges act on frivolous lawsuits, but to pass the Prison Litigation Reform Act, which almost demolishes the capacity of prisoners, any prisoner, no matter how good, how strong, how righteous a claim, to obtain damages, gives them procedural hoops to go through, modifies dramatically attorneys' fees, which makes it very difficult for prisoners to get lawyers. And that happens to the good suits, the righteous suits, as well as the suits that could well be dismissed. Same thing happens in, if you will, so-called tort reform, limit on punitive damages. Yes, there is a need to control inappropriate verdicts. That's why we have judges. That's why we have remitter. But what the legislature does instead is to chop off everybody's head and make it impossible for people to obtain truly compensatory and, in appropriate case, punitive damages because of the general rule. That's what happens with qualified immunity. Now, there's something else, and it has to be said. Qualified immunity in its elaboration, which is about 30 years old, arises in a social and historical and political context. It has to do with perceptions of the role of police. It has to do with perceptions of the role of being pro-police or anti-police. And qualified immunity serves a, if you will, the agenda of judges who are concerned to protect the ability of police to act with minimal regard for the consequences of their victims. Chris is very fortunate to have had the panel he did, and God bless Judge Gregory as well as Judge Floyd. Now, Chris, being the tiger that he is, would probably have won in front of Niemeyer and Wilkinson. But the fact of the matter is that judges have political attitudes and political preferences, and qualified immunity has developed through the Rehnquist court, now again through the who's the Chief Justice? Roberts Court. And without any regard as to the consequences, let me give you a notion about this. On May 15th of this year, in the middle of the social chaos arising out of the George Floyd death and the riots, when the Supreme Court had a dozen qualified immunity police appeals pending, and when not only the New York Times, which is of course a Marxist paper, or the Washington Post, which is kind of liberal, but George Will in his column saying, this isn't any good, you've got to take this away. Plus two judges, our Judge Floyd and Judge Lynn Edelman, a judge in Michigan, writing public letters, publications in the press. Judge Floyd had an op-ed in the Washington Post calling for qualified immunity to be done away with. The court denied every single appeal. And let me give you just a thumbnail sketch of what some of them were. Baxter versus Bracey, qualified immunity to officers who deployed a police dog against a suspect who had surrendered and was sitting on the ground with his hands up. Corbett versus Vickers, qualified immunity to a deputy who shot a 10-year-old child lying on the ground while repeatedly attempting to shoot a pet dog that posed no threat. West versus City of Caldwell, qualified immunity to officers who bombarded an innocent woman's home with tear gas grenades after she gave them permission to enter to look for a suspect. Cooper versus Flake, qualified immunity to officers who killed an unarmed man in his parents' home by tasing him 9 times while he was having an acute mental health crisis. Jessup versus City of Fresno, qualified immunity to police officers who, get this, stole $225,000 in cash and rare coins in the course of executing a search warrant. That's because no court had ever said that that violated federal law. It's true, look it up. Kelsey versus Ernst, qualified immunity to an officer who grabbed a small woman in a bear hug and slammed her to the ground, knocking her unconscious and because she walked away from him after he told her to get out of here. That's what our Supreme Court decided about 8 weeks ago. They have, it has to be said, an agenda. And it's our role to change it. I have just filed a cert petition in which I have raised these issues, but I have not made the legal arguments that have been made by so many lawyers in excellent presentations. And I should say, by the way, that the Cato Institute, it's a libertarian think tank, they have embarked on a qualified immunity initiative and provided absolutely superb amicus briefs in a lot of these very cases. The arguments, the law, the history, from a legal standpoint, from the standpoint of what we learned to do as lawyers in law school, it's unanswerable. Qualified immunity isn't in the statute. It didn't exist until the late 19th century. It was invented, the late 20th century. It was invented and then imposed, and we're dealing with it now. And I wrote a cert petition which addressed not so much the legal arguments, because apparently they don't seem to work, as some more underlying political and political theory themes that underline democracy and who has rights and who has power. I won't go into that now unless there are questions about it. One of the dramatically important things about qualified immunity is the negative consequences it has for the status of police in our communities. Imagine if you can violate the law and violate the Constitution and be immune. What does that tell the population? Particularly, what does it tell the victim population, or the population from whose folks are more disproportionate numbers of victims are chosen? It's a terrible situation for the police as much as it is for the intended plaintiffs. Of course, in the short run, qualified immunity basically means the defense wins, except in those few cases where the defense doesn't.
Thank you. I have a question, but I want to ask the other panelists if they have questions sparked by those comments. Chris, go ahead.
So, Victor, those are excellent comments. The one thing I've discussed is the fact that qualified immunity, not only is it a creature of the judiciary, it applies to all state actors. And it is so puzzling to me that while it applies to teachers and sanitation workers and anybody who's working under the color of the authority of the estate, for some reason, when it comes to police officers, we treat them with these baby hands like that's not where they're supposed to understand the law, right? So they are trained in the use of excessive force. They are trained on these issues. They are trained on dealing with suspects. They are trained on how to apprehend suspects. They are trained on Fourth Amendment laws. And yet, for some reason, when an issue like this comes up, we treat them like they work at a convenience store, and like they're these people who have no intelligence to be able to understand the very thing they're trained to do. It's that case about the tear gas, just to be clear for the listeners or viewers, they destroyed that woman's home. They were looking for a person. They thought he was in the house. She said, yeah, you can go look for him in my house. Well, they claimed we were in fear for our lives to go in the home. They bombarded her home with tear gas grenades that blew everything up in her house, destroyed stuff, the smoke, I mean, literally destroyed her home. And, with respect to the decision not to accept any of those cases on certiorari, Justice Thomas, as well as Justice Sotomayor, have joined in that position that this needs to be reviewed. That's what I'd like to add.
Yeah, well, it was very distressing that the two of them who have specifically said that it's necessary to review this issued no dissents. I think that people who are monitoring this, I mean, it's rather unusual. There were 12 cases presenting this very issue in the middle of the George Floyd business. And everybody who had their fingers on that pulse thought that, okay, the court's going to do something.
Well, yeah, and normally you might accuse them of trying to pass the buck to the legislature to fix it, but they created this doctrine, right? So you would think they would address it to try to sort of, it's so antiquated at this point, to try and bring it up to some kind of modern application.
Yes, yeah. And one word about what you say about the state actors. It's true, obviously, that the defense attaches to 1983, not to police officers, and 1983 attaches to all state actors. But the overwhelming amount of litigation involving state actors is police. So that's why we have so many cases involving the police. There are some cases that don't, and it's also broadly construed by the courts in that as well. But the results are not so shocking. Here, I mean, the notion that the court says, it's unfair to burden police officers with a consequence for doing something where they didn't know they couldn't do it. Well, that doesn't work. Why? It can be a violation of state law, and you can still get qualified immunity if it hasn't been deemed previously it'd be a violation of federal law. It can be a violation of police practices. It can get you demoted or even fired. But if it hasn't previously been established as a violation of federal law, it doesn't qualify according to the most conservative interpretations of qualified immunity, or at least by the most conservative judges. It's only in the most extraordinary circumstances that a situation will be permitted to go forward. A case will go forward in a unique state of affairs. Judge Posner has a wonderful opinion in which he says more or less that the fact that there is no prior case where social workers kidnapped a foster child and sold them into slavery doesn't mean that there wouldn't be a 1983 case. Well, the fact that he had to reach out to such an extraordinary example gives you some idea of what, in fact, you would have to do. I have a case now, in fact, it's the case in which I have the cert petition pending, in which I had 8 police officers in Fairfax standing around a neighborhood swimming pool with a guy drowning, with a lifeguard saying, I've got to go in and save him. And they said, don't go in. And so when he went in, almost 3 minutes later, he pulls out somebody who has neither breath nor pulse. I brought a case predicated on state-enhanced danger. There are very few cases of that in the country. There was one in the 6th Circuit and one in the 7th Circuit, both involving police direction to rescuers not to rescue. They both found constitutional violations, substantive due process violations in the form of the instruction, the direction not to save, and one found qualified immunity and one found no qualified immunity because we haven't had such a case before. And that's what Judge Ellis found, and the 4th Circuit agreed. And I've gone to the Supreme Court with a brief that reflects more of my background in European intellectual history than it does in law, and makes reference to the recent upheaval. And there are two bills in Congress right now seeking to modify or abrogate a qualified immunity, and maybe they'll get a clue. I don't know.
So, oh, sorry. Yes, Cynthia. Oh, okay. Well, you're on mute, so we can't hear you. Yeah.
I apologize. Victor, I wondered if it'd be helpful at this juncture in your response to Chidi's question to distinguish between the nature of the immunity that police officers and other public actors in Virginia might enjoy that is not qualified immunity if you are seeking redress for police officer misconduct under purely state law, because qualified immunity is not a concept under Virginia state law. It is, as you described, purely a creature of federal law in connection with Section 1983 cases, which is the statutory tool by which federal constitutional rights are enforced. So if I think this might be a good juncture to do that. And secondarily, are you aware of circumstances, and if not, why not, where plaintiffs have not tried to invoke the protections of the Virginia state constitution as against police officer and other public officer misconduct?
Well, I'll take your second question first, and that is
easier.
It is easier because I am not aware of any instance in which construction of the Virginia Constitution is any better on any civil rights issue than the federal Constitution, even at the hands of the pre-Obama 4th Circuit.
And there also isn't an enforcement tool of the nature of Section 1983. Is that fair to say?
I truly can't tell you because I have never bothered to plead these matters in state court or on state theories. We've had a revolution in civil rights, at least certainly in terms of employment and hopefully some more, starting just several weeks ago. In terms of the applicable date of the new statutes, and hopefully the judges will become educated and more sensitized, and maybe there'll be a rebirth of civil rights litigation in fields more broad than simply employment, where it's certainly predicted that there'll be a flowering of litigation. But that so far has not extended to to police work. One other thing, if I may, this isn't entirely on point, but it's important because people do ask about state court. Virginia labors under a really severe problem, so far as I'm concerned, with regard to its state judiciary. We are the only state in the union that has no appeal of right. A plaintiff or a party in your basic civil suit, you have appeal of right in criminal cases. I believe you have appeal of right in divorce cases and in some administrative decisions. But other than that, it's basically a cert system. And you file an appeal, and 9 times out of 10, you get back a piece of paper that says, we've looked at it, everything is fine. That's a catastrophe. A lawyer doesn't become brilliant and fair because they've been given a black robe. We all make mistakes, and we all improve by being criticized and corrected. And why is it that there are appellate courts? And how is it that Chris got a trial court reversed 3 times without a prejudiced judge, at least for purposes of our discussion? It's because people make mistakes. And when you have a system that doesn't permit review, particularly when what's at issue is an adversarial system in which there's a clash and there are all sorts of things at issue, that's very troublesome for proceeding in Virginia. And I, for one, view that as an ongoing problem. And I will view it even with regard to the employment claims that can now be made under state law.
Cynthia, my understanding is that states interpret the doctrine as not being limited to federal claims. So the doctrine of qualified immunity applies to state actors, whatever the claim may be, whether federal or state. Now, there are states like Maryland, which its constitution expressly denounces the ability to raise a qualified immunity defense. Colorado's legislature recently added that to their constitution so that their claims for violation of Fourth Amendment rights are not subject to qualified immunity defenses. And I think, Victor, that the Virginia legislature is now taking up the issue of whether or not to provide an appeal as a matter of right to the Virginia Court of Appeals prior to the next step with the cert process to the Virginia Supreme Court.
Yeah, I think that's true. And it's entirely correct. There are none. I'm sorry.
It's desperately needed. It's desperately needed. You are spot on.
But my goal here too, in asking those questions was really to inject into the discussion at this point the difference between the fact that public actors in Virginia enjoy to some degree, some measure of the state or the locality's sovereign immunity, which is not the same thing as qualified immunity that we've been talking about. So I was just kind of trying to get us there a bit. And that was the other part of the question I asked you.
All right, well, let me respond to that. Okay, so sovereign immunity, sovereign immunity dates from medieval England, right? You couldn't sue the king. The king couldn't break the law. It's kind of like Donald Trump. If he does it, it means he's right. Sovereign immunity provides that you cannot sue the state without the state's express permission. Now, the state has given express permission in, for example, the State Tort Claims Act. And that only addresses state actors, but literally employees of the state. So, for example, it can come into effect if you're beaten in the course of being arrested by a Virginia state trooper. You may have a tort claim against the state. If you're beaten by an Alexandria police officer, you don't. You don't.
You might. There are a number of exceptions, right?
Well, no, not if it's a city employee. Not if it's an employee or a county employee. It has to be a state employee. At least that's.
You mean with respect to application of the Tort Claims Act? Correct. I'm sorry. I was thinking about common law claims.
Yeah.
That the Tort Claims Act doesn't apply to when you sue a locality. There are exceptions to. I'm sorry. Go ahead. Excuse me.
Okay, the second issue has to do with what degree of offense needs to be attached to the act in order to overcome sovereign immunity, so that simple negligence is typically not going to make it. Some city officer or state, county officer, whatever, does something negligently, and you happen to lose your leg as a result. I'm so sorry. Have a nice life. That's how it is. You have to show gross negligence, and gross negligence is in the eyes of the judge who's hearing it, right? It's not impossible, but it's problematical. And you can have situations in which there is literally no claim, and then there's a third category, which is the viable claim. However, the defendant has been cut loose by his employer. Nice versus City of Alexandria. Police officer goes to a woman's house to think she was a witness in a case and rapes her. He gets prosecuted. He goes to jail. He has no assets. The victim brought suit against the city under the theory of respondeat superior. Wrong. No respondeat superior. It doesn't trump qualified immunity. The city is immune. The tortfeasor, the rapist, is in jail and doesn't have a penny to his name. Too bad. So we have a situation in which the government puts people in a position in which they can do dramatic harm. The officer who stops somebody in the middle of the night on the road. There are those cases. And rapes them, whatever. And then walks away from it. The city walks away from it. The county walks away from it. It's an abdication of responsibility for creating the situation which caused the harm.
Oh, thank you. Thank you. So I would like to introduce our third panelist at this point, although I think she's sort of been introduced already. And our third panelist is attorney Cynthia Hudson. Cynthia is presently counsel with the law firm of Sands Anderson. And for 6 years before that, she was a chief deputy attorney for the Virginia Attorney General's office. And she was the first African-American woman to occupy that office. She's also a former city attorney for the city of Hampton. She's taught state and local government law for William & Mary's Law School and is former president of LGA, which is Local Government Attorneys Association. She earned her bachelor's degree from VCU and a law degree from William & Mary. As chief deputy in the Attorney General's office, she played a critical role in many landmark cases and many policy decisions, like the Bostic v. Rainey case. And that's the case where the Attorney General succeeded in challenging Virginia's ban on same-sex marriage. And one interesting thing that I do remember about that case, which you told me about as well, is it was one of the rare cases, although it happens, where the Attorney General's office takes a position that is different than what that state law is. So that was one of the cases that she worked on right when she got into the office. In addition to that, in 2015, she was inducted into the Virginia Law Foundation as a fellow and was awarded the Oliver Hill Civil Rights Leader of the Year Award by the Richmond NAACP in 2018. In 2019, she was named to Virginia Lawyer Weekly's first class of influential women in the law. In June 2019, Governor Ralph Northam appointed Cynthia to chair his commission to examine racial inequality in Virginia law. And earlier this year, in the wake of George Floyd and Breonna Taylor killings at the hands of police and the protests, the Governor Northam reauthorized the commission to continue its work and continue with Cynthia as the chair. So Ms. Hudson, My third question, well, it's more than three questions, but my next question is to you. And that question is, how are local and state governments responding to the recent demands for change? And do you see a difference in what's currently happening as compared to civil rights movements in the past?
First, thank you, Chidi, for the kind introduction and for having me here today. Good afternoon, everyone. As I sat and listened to Chris and to Victor, it occurred to me that I'm probably the only one on this panel who has actually represented police departments as clients and individual police officers as defendants with respect to some of the conduct that we're talking about, which may seem a little bit inconsistent with some of the other roles, current roles that I have that Chidi has described. So it's certainly helpful to remind the legal community that there's more than one way to skin a cat with respect to where you get in protecting folks' civil rights. As someone who represents police departments, and clearly I represented as general counsel the police department of the city of Hampton for nearly 16 years, first and foremost, you gain an appreciation for the extent to which policing is a good and noble profession filled with good and noble people who do the right thing and try to do the right thing. So, you know, at the sake of you know, beating the usual drum about a few bad apples, I won't do that, because one bad apple is more than anyone who's lying on the street with their life at risk should have to confront. But as a city attorney advising police departments and the city managers and city councils and boards of supervisors for whom they work, it is just as important that I prevent police officers who do not comply with training and who do ignore law and who do mistreat people, that I make sure that they're not in the police department that I advise, that they're not on the street. And whether that's because we have the right policies in place with respect to hiring them in the first place and appropriate recruitment and screening, or whether it's somewhere further along the spectrum and you have put in place, with the city attorney's involvement, some mechanism by which there are red flags or early warning systems that this is an officer you might need to watch, so that not just as a matter of good risk management, but as a matter of being the right thing to do, you don't put the public at risk of errant police officers. And I use errant as a mild term, obviously. And then when misconduct does occur, and you are facing possible lawsuit, liability, injured victims, families who are left bereft because a loved one is dead or a loved one has been mistreated by police, then the right thing to do kicks in there too for local government attorneys, and that is to advise police chiefs and city managers and county executives and boards of supervisors and their department and their risk managers that this is a case you should resolve, and here's why you need to resolve it, as opposed to necessarily plotting ahead and beating victims over the head with qualified immunity and sovereign immunity, when the goal of city government should be first and foremost do the right thing by its citizens. And that was the lens through which I viewed my role as advisor to the police department. Obviously, as chief deputy, you take on a whole nother set of law enforcement agencies as clients: state police, ABC, Game and Inland Fisheries. All of these folks and more are law enforcement officers. And again, you bring that same lens of do the right thing, in my estimation, to that lawyering as well. So with that said, I'll move on to answer your question, Chidi, more directly regarding state and local government response to the issues that have been brought to bear by the recent police killings and the protest activity in the streets that that has resulted from that. It might not be an overstatement to say there's almost a race to policing reform right now. And I don't know how many states are in the race, but there are a good number of them. And I don't think I'm misstating it to say Virginia's in the race. There is a special session of the General Assembly that was originally contemplated to address budget issues arising from the COVID-19 pandemic, but in the wake of the George Floyd and other killings of minorities at the hands of police recently, is rapidly seeming to shape up to be shaping up as one where policing reform or police reform will be addressed in Virginia. Certainly speaking with the hat I wear as chair of the governor's commission to examine racial inequity in the law, we exist. This commission consists of, myself, former Commonwealth's attorney Mike Herring. There are attorney educators from law schools. There's an attorney with the Jill Hankin with the Virginia Poverty Law Center. There are former and current judges, retired Judge Bertie Jameson, current Judge Gerald Jones in Norfolk, and we've all been a body. This has been a body actually since June of 2019. And the first order of business, the first phase of the work of this commission, which of course predates all of the recent civil rights unrest, was to take a look backward and say, what's still on the books in Virginia, which clearly our state played a huge role with respect to how race relations have been shaped and the existence and quality of life, or lack thereof, of minorities has been in this country since we arrived here in 1619. And certainly from my perspective, I've always said, given our role, given this state's role in shaping the existence or the state of the existence of Blacks in this country, we have something to do with respect to fixing the state of that existence, whether that disparity exists in policing, criminal justice more largely, as a general matter, housing, employment, voting, education, transportation, any area of life that's important to the quality of your life that you can think of. There is a disparity with respect to how minorities receive or don't receive opportunity or the same level of quality in public policy, and non-whites and whites rather. So the idea that I would, that we would first look back and see how we got here, I thought was very fitting for the commission. So the first phase of our work culminated at the end of December with taking a look back and just pulling out of the Acts of Assembly all of the statutes that basically were the tools for Virginia Jim Crow laws and tools that were the infrastructure of massive resistance. And while obviously the law has evolved, Constitution has evolved in Virginia, federal statutes and all of the fruits of the prior civil rights movements have changed the law. They're nonetheless in the Acts of Assembly. We recommended bills to the governor for his legislative package that were passed unanimously by the General Assembly and signed by him to actively and affirmatively repeal those laws. With that out of the way, we have turned now to current law and how it may contribute to the disparities in the various areas of life that I talked about. And with that, we come dead center to policing reform. In reauthorizing the commission this past June, at a time which was maybe within just a couple of weeks of the George Floyd killing, we already had on our agenda for that commission examination of various titles of the Virginia Code, where we would look to see if unintentionally or otherwise there were laws on the books that were contributing to the kind of racial disparities that I'm talking about. We had ordered it, criminal justice, education, and then moving on to others that we would take up in series. The governor, given the timing and what we were going through, and as we were in a press conference with riots in the street at the time, or protests, I should say more accurately, the governor asked us to prioritize policing reform recommendations to him that he could then translate to either legislative proposals with an upcoming General Assembly session, to administrative rules with respect to the Department of Criminal Justice Services and other executive branch agencies that are under his authority under the Virginia Constitution, and to do so in quick order. And that's what we've done. But we are in good company in coming up with those proposals. And as it turns out, the state government response, which hadn't been totally formulated yet in Virginia, I think is going to be a very loud and very effective one. And just as Victor described almost a sea change with respect to civil rights as it relates to employment that came out of this past General Assembly, I think it's going to be just as significant with respect to criminal justice and policing in particular. We concluded a meeting yesterday of the commission I chair, where we completed review of a range of policing reform proposals that will now be sent over to the governor's office for his consideration as legislative proposals to be put before the General Assembly in this special session. But we won't be alone, and we will be singing pretty much the same song as the Virginia Legislative Black Caucus, as the Virginia Democratic Caucus, as to some degree the Virginia Association of Chiefs of Police, which has its own slate of changes that it's looking for in policing. They're not exactly the same, but you'd be surprised where they coincide with the reforms being called for by the commission I chair. And let me just briefly speak to, with a bit more precision, what some of those proposals are. With respect to, and they fall into various categories. With respect to accountability for misconduct and the consequences of police misconduct, this commission has proposed or is proposing to the governor that there be a rollback, some limitation of sovereign immunity as it applies to police officers, and possibly, more broadly in terms of public officers who, by the nature of their responsibilities, are in a unique position to cause certain harms. I, for one, advocated against a complete rollback, which some public policymakers are calling for. Sovereign immunity plays a very important role with respect to the work and the responsibility of government and government actors, but there can certainly be a look at limiting the extent of the application of that immunity in order to affect the kinds of reforms that people are demanding.
May I ask a quick question?
Sure.
The proposal that you're making about accountability and moving, I guess, limiting sovereign immunity, putting some limits on it, is your proposal suggested to be retroactive for cases that are currently pending, or would it only be for anything that comes after it's enacted, if change enacted?
Well, Chidi, just to be clear, our commission's charge is to recommend to the governor in a fairly, I don't want to use the word general, but we don't drill so deeply into how these things are accomplished as much as accomplishing a particular direction with legislation in a particular area. So while we might, in fact, the recommendation, and let me just find it for you, with respect to accountability as it pertains to immunity protections, the recommendation is that that the legislature, or that the governor recommend, and legislation that he would then craft, that civil liability for police misconduct be strengthened, that that sovereign immunity protections be limited for law enforcement officers engaged in misconduct and for their employers. Again, that is a broad recommendation, but you really can't tie the hands of, as if you could, the governor and the legislature. The idea is we recommend that you move in this direction with a legislative choice that obviously you make in deciding exactly how the legislation is crafted and how it reads, with the understanding that it has to be left to others to make sure that any inconsistencies and cross references with the application of other law and other actors, public actors, is taken into account. Also in the accountability area, we approved a recommendation to the governor to create civil liability for, in particular, for bias-based profiling as defined by Virginia's racial profiling law 52-30.1, which while recently passed had no enforcement mechanism. So the recommendation is that there be an enforcement mechanism that creates a cause of action, a civil cause of action for police profiling on a racial or ethnic basis. Provide additional decertification criteria for law enforcement officers based on repeated or serious misconduct or dishonesty, those terms to be defined again in the legislative process. That is somewhere where we see eye to eye with the Virginia Association of Chiefs of Police. Right now, police officers in Virginia, there are very limited bases on which they can be decertified from policing, which promotes this moving from one agency to another. Once you have been engaging in misconduct in one agency, you go to another jurisdiction, which may or may not know about your record and perhaps practice policing in the same way. In particular, we have recommended that decertification criteria or bases also include records, as I said, of misconduct that fall short of criminal conviction of any nature. And right now, that's pretty much the most, the usual basis for decertification. We've also made recommendations in the area of transparency and data collection so that we know what we're dealing with statewide with respect to the incidence of police misconduct. And the data collection recommendations involve the requirement, and again, this coincides to some degree with what the chiefs of police have said is reasonable, is that data be collected with respect to all kinds of police stops, not just traffic stops, but also citizen engagement on the street with pedestrians. And in order to collect demographic data and get some idea of exactly what the extent is of perhaps disparate treatment by of citizens on the basis of race by police officers, you collect as much demographic data as you can about the subject of the stop. You have to document exactly why you stopped that individual or thought you should have a conversation with him or her and what the outcome is. And that data would be centrally collected at the state level. And there would also be increased reporting and a required mandated reporting with a narrative accompanying it of any use of force, in particular, a use of force that results in injury in the course of policing. And I don't want to exceed my time, Chidi, so stop me, because there are several more proposals that I could just briefly describe.
That was great. Thank you so very much. Are there any proposals that you haven't mentioned that have sort of universal support with other interested parties? I know you mentioned that the police commissioners are in agreement with the decertification proposals. Are there any that have sort of unanimous support?
Well, I won't say unanimous, and I'm speaking to the extent
that you're aware of.
The commission that I chair made a recommendation. I'm glad to say the support on the commission was indeed unanimous for all of our recommendations. With respect to the other entities that are pursuing kind of the same agenda with respect to policing reform, I wouldn't say that they lock on all fours with respect to each proposal. For instance, there's another category that we described as reducing the risks of policing, where we suggest that the governor seek legislation that mandates the adoption by localities and all law enforcement agencies of a model use of force policy, and that local government law enforcement agencies in their policies, they must meet certain minimum requirements that are established by the state with a focus on de-escalation where necessary and where appropriate, and training in that regard, banning or at least limiting, further limiting, we should say, no-knock warrants, limiting the use of chokeholds. These measures have gained widespread support, not just among the other interest groups in Virginia who are seeking policing reform, but across the country. I am aware that in the wake of the George Floyd killing, there have indeed been states that have passed legislation, not just considering legislation or contemplating proposals, but have passed broad sweeping policing reform legislation. Colorado, I think, was the first out of the gate. Minnesota just this week. Massachusetts has one that has passed the Senate, is now in the House, where perhaps it might not have an easy fate. I'm not sure. Connecticut. I think if you look in almost every state, nearly every state right now, there is some measure that has gained much greater traction than it ever has, at least in my lifetime, for policing reform. It is a movement. I believe that it is indeed different than other police killing aftermath conditions we have seen in recent years or the last 25 or 30. I think it's real this time. There's even a push at the federal level, as you know, with the House having passed a policing reform bill that would carry George Floyd's name. It has hit rough seas in the Senate, but nonetheless, something is going to come out of that. So yeah, I think we're living in different times. I have to say, on a personal level, I'm glad to be living during this time and having a voice at the table. Because, I always, I look at the PBS documentaries, Eyes on the Prize and that kind of thing, and say, gosh, look at what those individuals, look at what the people whose shoulders I stand on were doing in the streets back in the 50s and the 60s. Would I have just been sitting at home watching them on TV, or what? Would I have had maybe I would have been, but at least right now, I have a seat at the table, and I hope can honor the sacrifices, the physical sacrifices they made out in the street by continuing the work that they started. So it's good times as far as I'm concerned.
And Victor is one of those people.
Exactly, I know. And Victor, you didn't tell anybody that we were on the other, we were on opposite tables of that whole marriage certificate racial inquiry, but it worked out right, didn't it?
In the end, it worked out right. I don't know why y'all didn't come on board immediately, but these things happen.
We got there. It all worked out.
So we're pretty short on time. I want to see if the panelists have any questions based on Cynthia's comments, and then I have one question from the audience.
I have a question for Cynthia. How do, in your experience and given your work with the police departments, is it really realistic to believe that there's going to be reasonable and sufficient self-policing by the police? I ask because I've had any number of internal affairs investigations. 99 out of 100 are whitewashes. I'm not going to read here. I've got a wonderful example where the do I have time to read a little bit, Chidi?
I wish you did, but we're just about out.
What do you think it's realistic that there'll be self-policing of a meaningful sort within the department?
I can only speak from the microcosm that was my experience in Hampton. And when I say that 99.9% of my clients in that department and the chiefs who led them would strictly self-policed, yes, I would say you can look for meaningful self-policing and greater scrutiny of fellow officers who don't do what they're supposed to do and don't follow the law and observe the constitutional rights of the people they police. Yeah, I feel very confident of that. But it's not just because I think there'll be some transformation personally in all of them. It's because there's this confluence of events right now that I think will force it, to the extent anybody is at all reluctant or resistant to change. And to the extent the screws are tightening, I think the bad apples will leave.
Right.
I really do. I mean, one of the responses of the police community is that, look, you're making it too hard to be a police officer these days. You're talking about taking away, you know, my immunity. You're talking about these new standards. And quite frankly, that's exactly the kind of pressure you want to exert on the people you don't want policing in the first place.
So we are out of time. I don't know if the thing is going to cut us off or not, but I would like to get at least one question in from the audience. And the question is for you, Cynthia. It says, can you comment on the Law Enforcement Procedural Guarantees Act, and how does it impact the way police chiefs discipline bad apples?
The Law Enforcement Officers Procedural Guarantees Act kicks in to address the manner in which and the procedure, as suggested by the name, by which police officers are determined to have violated policy. Whether you're talking about the policy on honesty, because, you know, at their essence, police officers are professional witnesses, and the preservation of their credibility in that component of what they do is all important. And at the other end, it might be criminal conduct, but it preserves or guarantees for police officers that they will have, and it's really a gloss on the procedural due process rights they already have, that they will have sufficient notice and an opportunity to be heard. It has particular weight for them, though, with respect to the manner in which they can challenge disciplinary consequences. Every other public employee in Virginia, or I'll talk on the local government level, has available to them, if they're a certain class of employee anyway, which most of them are, a grievance procedure that each locality is mandated to have by the state, pursuant to which they can challenge grievable discipline as being without just cause, or for other reasons that they set in motion and follow a procedural process to challenge a written reprimand, a suspension, and certainly a dismissal or a demotion. Police officers get to that, they have a choice they can make when they get to the point where discipline has been issued. They can either follow that locality's generally applicable grievance procedure, which, you know, may take a totally different form than another path, which is police officer selects a panel member for the final hearing in that process. The city management or police chief of police usually selects the other, and then those two select a third for the final say on whether or not that discipline was appropriate and will be upheld. That is probably the biggest strength of the Law Enforcement Officers Procedural Guarantees Act, because I think you can see the opportunity for the law enforcement officer, depending on what locality he's in or she's in, and his or her history there, to maybe have a better shake under that process versus one, say in Hampton, for instance, where the grievance panel was made up of 5 people who were appointed by city council based on, hopefully and typically, their experience with employment law and with public policy and those kinds of things, and where some law enforcement officers might have seen that panel as a pawn of management, which is not the case necessarily, but that's an important right to have to pursue your own brand of grievance process.
Okay. All right, well, thank you very much. We are out of time, 4 minutes over time. I am so grateful to each of you for your dedication to your jobs and your professions, and for the inspirational work that each of you do, and that you're willing to come and share that with us. If we were in person, there would be a round of applause and ovations, and people coming to talk to you later on. There'd be a line of people standing trying to ask you questions about their cases and ask you for assistance. So if there are people who wish to reach either Chris Brown, Victor Glasberg, or Cynthia Hudson, just send a message. And then we can make sure that you have the ability to reach out to them, get their email addresses or whatever. So with that said, thank you very much, and thank you to all of you who tuned in. Thank you to the Virginia State Bar for allowing us to put on this this town hall, and thank you to the members of the Young Lawyers Conference and Diversity Conference for being forward thinking and putting this presentation together. All right, thanks everyone.
Bye.
Thank you, Chidi.
Have a great day.
Take care.